Jay, you're going to do...
Yeah, I'm going to talk a little bit about this stuff and Michael Morton, et cetera, while you're setting that up. Criminal justice and criminal justice techniques have changed dramatically in the last 20, 30 years, and especially in the last 5 years in the state of Texas. And what I'm going to start talking about, and by the way, this is just, I was asked yesterday or day before yesterday if I would help with this, and I'm happy to do it. And I'm just kind of speaking off the cuff, but this is very important to talk about. Article 3914 in the Code of Criminal Procedure governs discovery in the state of Texas. And based upon recent events within the last 5, 6, 7 years of convictions of individuals who were not guilty but were convicted with, despite the fact that the defense that they had was not given evidence that was withheld by prosecution and prosecuting authorities. And the most famous of them is the story of Michael Morton, who was a guy that was convicted out of Williamson County like 30 years ago for the murder of his wife. And Michael Morton sat in prison for 25 or 26 years before he was released, and the release was after about 2 or 3 years of writ of habeas corpus evidentiary proceedings in Williamson County to try to get the evidence that was never turned over to his original trial counsel. And I'm going to read a little bit about what happened with that. He was wrongfully imprisoned for 25 years for his wife Christine's murder because prosecutors withheld exculpatory Brady evidence, a bloody bandana found at the crime scene. And this bandana was found about 100 to 150 feet away from the house near a wooded area, but was never turned over in response to discovery requests by his lawyers.
Your Honor,
yes.
I have a question from a juror.
We have a question from the jury.
Yes.
What is the question?
What's the question?
They ask if they could come ask a question to the judge.
Well,
should I bring them down? Or just
well, I'm not going to, I mean, just tell them to do the best they can, because we can get into questions and that can go on for hours.
Okay.
So tell them to please continue deliberations, and if they reach an impasse, to let us know and we'll come back, okay? So later testing of this bandana revealed that the blood belonged to a person named Mark Allen Norwood, who was convicted for a different murder in 2013. And two years after killing Christine Morton, Norwood murdered Deborah Baker, a mother of 2, under very similar circumstances, and it was his DNA that was found on that bloody bandana, and Morton was released. Michael Morton then went to the Texas legislature and lobbied, along with the Texas Criminal Defense Lawyers Association and others interested in reforming the discovery process in Texas, to tighten up discovery, production, and documentation in Texas. And now under Article 3914, which is considerably rewritten, the state of Texas is under an affirmative duty to tender to defense counsel upon proper notice, it's written notice, all of the evidence the state intends to rely on, as well as Brady evidence, and there has to be a very specific documentation process done, and that is now the law in Texas. So hopefully Michael Morton's won't happen. There are a couple of other cases that I can't remember the names, but that's happened in those cases as well. So now the state of Texas really has to give it all over. And there has been a practice in Texas for many years. I mean, when I was in the DA's office in the early 80s, it was a common practice in Harris County to have an open file and allow the defense attorney to take notes, make copies of certain things, even parts of police reports in order to satisfy discovery requirements. But some counties in Texas wouldn't do that. They would just say, file your motion, and there would be this cat and mouse game of, I'll give you this, and then they'd press a little more, I'll give you that, and well, let's go talk to the judge because I've heard such and such, and they get in front of a judge on the record, and it was just teasing out of evidence that happens a lot in smaller counties. And I'll be frank with you, it happened in a few cases in Harris County and some of the larger counties where the prosecutors didn't want to have an open file, and they would press on a few cases, and they're typically high-profile cases. But most of the cases, they had an open file. Michael Morton now requires documentation, all of that. It's a great law, and it's still evolving, but it's a good thing. Now, with regard to identifications, the typical way identifications occurs, a detective will call a witness in to a room, and they'll put together what's called a photo array, or what's also known as a photo spread. And they're pictures of, the main suspect and 5 other people that are supposed to be similar in appearance. And the photo array is typically put together by the investigating detective. Well, ABA guidelines and also guidelines by people who are experts in criminal investigation counsel that the photo array or any showing of photos should be done by an independent police officer that's not involved in the investigation, and that the photos should be shown to the witness one photo at a time rather than in a series or an array of photos. And I don't know that HPD or any of the Harris County agencies are doing that yet. They're still showing photo arrays, but there's a movement afoot to try to get the identification process more in line with best business practices or best law enforcement practices. But that's another area. And we were talking about eyewitness identification earlier. One of the last cases I handled as a criminal defense lawyer before I became a recovering lawyer as a judge involved eyewitness identification in a rape case and in 2 robbery cases. And I was one of the first lawyers in Harris County to use an expert witness to attack the reliability of an eyewitness, and particularly in a cross-racial crime. And I had long Daubert hearings in both cases. In one case, my expert was allowed to testify, and the other case it wasn't, but I was able to make the argument in front of the jury. And in 2 cases, I got acquittals, and one I got a dismissal. And again, eyewitness is a very, very crazy area. People say, they point to the person, he did it. Not necessarily the most accurate. In fact, probably the least accurate. And so you're seeing police officers now more and more corroborating eyewitness. It used to be in the old days, once they had the eyewitness, case closed, that would be the end of the investigation. It really should be the beginning of the investigation, and have the law enforcement look at other supporting facts, supporting the eyewitness identification. So that's about all I have to say about the history of these procedures.
What you're going to see is an...
Question.
Go ahead.
Why one at a time pick the photos instead of in a array?
Yes, Catherine, are you raising your hand? The theory behind it is to have the witness look at a picture and say, is this the person or not? Yes or no? And they say, no, that's not the person. So that photo won't be shown to the person again. And then sometimes the witness will go, I think so, but I'm not sure. And they may come back to that later. And then they keep showing photos of other people, that might be, that fit the description. And usually the description is given orally or verbally by the individual. 5'5" in height, blue eyes, brown hair, white beard, et cetera. And then they try to find, photographs in the suspect photos, and they look for these photos, and they have like libraries of these photographs, and then go one at a time and show them. So the studies show that it's a more accurate way for the witness to focus on this one photo without steering them. And also in the past, a very interested detective trying to close his or her case might show the photo spread on there and put their thumb on the photo of the one that they want them to pick. And there are very subtle ways that somebody can show a photo spread and get the witness to pick the picture. I'm not saying that all police officers do this, but I'm just saying there's a potential for that to be done. And so the way to prevent that is to have a disinterested from the investigation officer showing the photographs in the process of trying to get an identification. It's just a cleaner way to do it, according to all the studies and according to the ABA guidelines on recommendations for changes to the system. That's why.
So,
The lineup in the Oswald lineup was...
well, this is what we're going to go over. So this is an excerpt from Burt Griffin, who is a senior judge in the Federal District Court in Ohio, but he's also a former staff attorney on the Warren Commission. And so we're going to have Jay and I can have a little tag team here, and Amanda could step in as well. Kind of just go over the chronology of Oswald and how his rights were handled and compare it to now. So this is a commission statement about Oswald not being subjected to any coercion, and he was advised by his rights. And then this is Captain Fritz, who was notorious for getting confessions. Not very good at detailing police work, but apparently very good at getting confessions. And this is, or for the lawyers in the room, we're going to blow through this because actually the jury's going to be coming down in a few minutes. This is, this 1963 was before the Miranda decision. The lawyers, this is just a quick review here. Voluntariness standard. Then 64 is kind of the magical time we have. And then we have the Malloy decision that applied the Fifth Amendment to states. Messiah, I'm getting out of my regime now. Escobedo, and then he's requested, you have an opportunity, if you request counsel, he needs to have it.
And notice the votes on these decisions. They're 5 forms.
Yeah.
Okay.
This is during the Warren Court.
Yeah. So reasonable, good decisions barely sneak by.
Yeah, yeah. And there's some question about whether Burt Griffin in his original presentation had a slide about, did the Warren Commission experience affect some of these decisions? But I didn't hear his presentation because the Case Western didn't put that online. We have the Miranda decision in '66, so here's Oswald. And this is his first statement. This is in the Texas theater. Well, it's all over now. And this is a voluntary statement, so presumably not subject to Miranda.
And by the way, under Texas law, Miranda is triggered when somebody's in custody and they're interrogated. When they're not in custody, and there's a whole body of law, your jury can come in, there's a whole body of law that defines when somebody's in custody.
The jury's come in?
Whether they're free to leave,
Okay.
whether they subjectively feel that they're free to leave, and there's a whole argument that's done on whether someone's in custody, and it has to be interrogation. So somebody's sitting in the police car saying, you know what, you guys got me, I did it. That's not interrogation, that's not a confession, that is just a statement against interest by somebody who happens to be sitting in the back of the police car.
And that would be admissible.
That would be absolutely admissible.
Okay.
Not when a defendant, even in custody, makes a statement not in response to custodial interrogation, that comes in.
That's
Absolutely.
admissible. Yeah.
So,
Yeah, it is admissible.
so you already covered this before the jury came in?
Yes.
Okay. And then we have the first interrogation. Oswald's in the Captain Fritz's office. Captain Fritz tells the Warren Commission that, he told him any evidence would be used against him, and it was actually very similar to what would have been required in Miranda several years later. And then we have the invocation. He said he wanted an attorney in New York. Kathy, what did we talk about in terms of 14 days? Is there some?
Yeah, if you invoke your right, once the right to counsel attaches, if you invoke your right to have an attorney, and you can't be questioned about the subject matter of that offense until you've been released from custody for 14 days.
But they can still hold you in custody. They just can't talk to you.
Hold in custody, but
Okay.
you can't question you about that process.
Okay. Then we have some more case law on invocation. I don't know if, Jay, if you have anything you want to say about these cases?
That's self-explanatory.
Okay. And then question is a waiver as to whether after Oswald, I think it's the next slide. Yeah, so after Oswald said he wanted a lawyer, then Fritz asked him questions again and he answered. So question about whether there's a waiver.
And under the law now, there has to be some attenuation, okay? They can't just, he says, I want to talk to a lawyer, and then come back a half an hour later and and push him and push him. There has to be some attenuation of time and circumstances, and, there has to be some water passing under the bridge a little bit before they try again.
So it appears that at this point in time, he made a clear and unambiguous invocation of his right to remain silent, right to counsel. And Fritz is saying he once more asked him if he wanted to have counsel. So now we have the first lineup, and this is with Helen Markham. Now, again, at this point in time, Oswald was only in custody for the murder of Officer Tippit. And this is Helen Markham, who is one of the witnesses. And Oswald, again, demands a lawyer. He complains about the lineup. There's case law here, obviously after 1963, about the defendant has a right to have counsel at the lineup. And it applies to charge only after charges are being brought against a suspect. I'm not sure if the charges were brought against him. I don't think so.
I believe a complaint was filed.
Okay, okay. And so these are the three guys that were in the lineup. And there's Oswald.
Which is why I didn't use it.
Right. So he's complaining that, and not only is he complaining about the way, the way they're dressed, but by virtue of complaining, he's obviously sticking himself out. So the question now is, whether the lineup on the totality of the circumstances is suggestive. And here's more impermissibly suggestive case law. Jay, you have any comments about this?
Well, it's about minor discrepancies, no problem. You're never going to have a perfect lineup, ever. But the law allows minor discrepancies, but they have to be fairly similar, okay? Like, for instance, if you have an African-American suspect, you don't put him in there with 4 or 5, Caucasians, okay?
Right.
It's common sense.
So this is how, this is Mrs. Markham now is being, she's testifying before the Warren Commission. Mr. Ball is one of the attorneys. And he's asking her about her ID of Oswald. So now you went in the room, you saw these people, yes, sir. Did you recognize anyone in the lineup? No, sir. You did not? Now he's surprised. You didn't see anyone I asked you this question before. From their face, no. Didn't find anybody in these 4 people? No, I don't know anybody. I know you didn't know anybody, but did anyone in that lineup look like anybody you had seen before? No, I had never seen one of them, none of these men. Not one of the 4, not one of them. Was there a number 2 man in there? A little suggestive. Number 2 was the one I picked. That happened to be Oswald. What did you say when you saw number 2? Well, let me tell you. I said the second man. They kept asking me which one. I said number 2. When I said number 2, I just got weak. When I saw this man, I wasn't sure, but I got cold chills just run all over me. They said which one? I said number 2. So when I said that, well, I just kind of fell over. Everybody in there, was beginning to talk, and I don't know just. So that is the identification of Oswald. Any comments?
Well, whoever is interrogating an identification witness, if they're pressuring them and pushing them, then that identification is beginning to get tainted, and it gets tainted, sort in proportion to how much they're getting pushed. You got to ask a fair question. If somebody says no, didn't see anybody in there, they really need to move on.
And if he had counsel, he would have heard. Counsel would have heard her statements, right?
Exactly, and would have said, I object to this, let's do something else.
So now, having already invoked, now they bring Oswald back in for further questioning. There's a second lineup. And then he's arraigned at 7:10, the night of November 22nd, for the killing of Officer.
Arraignment suggests that a complaint has been filed.
Okay. Now, at around close to midnight, Oswald has a midnight press conference, and this is where he publicly asks for a lawyer. He asked for someone to come forth. He didn't shoot anybody, and he publicly comes forth and asks for legal assistance. Kathy, I forgot, is this the wrong slide? No right to cancel this hearing? At the arraignment. Is there a right to counsel, Jay, at the arraignment?
At the arraignment, it's a critical stage of the proceeding, yes, because he's been formally charged, by a complaint. That's a critical stage of the proceeding. Because at the arraignment, it's typically on the record, he could say something there that incriminates him.
Okay.
He has to have a lawyer there to advise him.
So now there's a third lineup with Barbara Davis.
And by the way, let me say this, in misdemeanor court, I enter a not guilty plea for people and tell them, wait till you talk to your lawyer before you say anything in court, and I tell them what their rights are and so forth, because you typically don't have a lawyer at the arraignment. So I enter a not guilty plea automatically. So you can change your plea after you talk to your lawyer. I just try to play it safe.
So now he has yet a third lineup without counsel. So at least, I guess maybe in 1963, maybe after the arraignment, he had a sixth right of counsel. Don't know, now he would have at the arraignment, clearly, right? Yeah. And now his fingerprints and palm prints are taken. He refused to sign the fingerprint card until he talks to an attorney. It's a pretty sophisticated guy. And now, here's a question, is fingerprinting non-testimonial, or is it such?
It's non-testimonial.
Non-testimonial. And is it considered a critical stage? We're already past the critical stage though, right?
No, but since it's non-testimonial, they can fingerprint you and all of that. But if they want to take, like blood or stuff like that, then it goes into an intrusive method of identification. Then I think you have a right to have it.
Okay. And then at 1:30 in the morning, before a justice of the peace, he's arraigned for the murder of President Kennedy. States he wants once again he wants the lawyer. And then the next morning, he's getting interrogated by Detective Fritz. And this is the testimony for Detective Fritz. Did you at any one time, did he tell you at any one time he didn't want to answer any questions? Yes, sir, he told me that 2 or 3 times. This morning he told you that, didn't he? He probably did. Now Oswald meets his wife and his mother. It's interesting, the police said that they did not tape the conversations, but later on in some of the Warren report testimony, they have verbatim conversations between Ruby and his sister.
Okay. Letting him meet with his wife and his mother is an attenuating circumstance, so if they want to come back and talk to him later and see if he wants to give a statement after that, after giving him a meal, a cigarette, let him get a little rest, whatever, those are considered attenuating circumstances before they can start trying to talk with him again.
Okay. Now he has another lineup at 2:15. This is Saturday afternoon, and this is the guy that drove the cab driver. And this is another witness to the Tippit shooting. Again, all about Tippit. Fourth lineup, so after the arraignment of the murder, Sixth Amendment, obviously he still has the... and then Oswald meets with his brother, and he declines his brother's offer to find a local attorney. Oswald was insisting on an attorney from the American Civil Liberties Union. Then he calls Ruth Payne, who we've heard about, that's where his wife was staying, and asks her to contact this particular attorney. And she doesn't. Then he's visited by the local Dallas Bar Association. He declines their offer. He again wants to speak to Mr. Aft. Apparently they called him at home instead of at his office. It was the weekend and he wasn't home. Now he's interrogated again. Now at this point in time, at 6:30 on Saturday, he's finally confronted with this photograph. So Bill, they got the photograph Friday afternoon?
They got it sometime Friday or Saturday.
Friday or Saturday. So now he's denying that this is him. It's a composite. He knows about photographs, and that's his statements.
Smart guy.
Yeah. So these are his denials. He denied owning the rifle. He denied the authenticity of the photos. He denied ever living at Neely Street. That was clearly a lie. He denied having post office boxes. I think that's clearly a lie, right, Bill? And he denied ordering the guns through the mail. So we have 3 questionable statements and 2 outright lies. Now, that was his last interrogation before he's shot. So one of the queries that I was talking to Kathy about was, if he had counsel at the time that he was identified by Markham, would the counsel been able to try to get him released on bail so that he wouldn't be in a position of being shot? I don't know what you would think.
Yeah.
We have a public safety exception. I don't know. It doesn't seem like...
Earl's case was very interesting. It's the weapon in the snow, and they talk about what if a child comes and finds this weapon and shoots themselves and basically makes the suspect feel guilty, all right, and then Quarles was confronted with this gun. Gosh, if we could just find the gun, we might save a life if some kid finds it, And Quarles says, okay, the gun is in the snowbank over here, they say you can't do that.
So I guess we were trying to speculate about what could be the public safety exception here, and presumably the Dallas police are concerned there's still other plots, other conspirators. Although J. Edgar Hoover at 4 o'clock in the afternoon on Friday has told LBJ, we have our man, and there's no conspiracy. Now, I don't know whether the FBI's conclusion preempts a state concern about safety. Probably not, right?
It's the dual sovereignty rule,
Yeah.
which the state has a right to prosecute, and the feds have a right to prosecute.
So that's a short review of how Oswald was handled during police custody. Any comments, questions, or for the lawyers in the room?
If Joe Jones were murdered in Dallas or Tom Smith in Pittsburgh today, even if some eyewitness saw that shooting, the police would not say that the case is over, because they don't know who drove Joe or Pete there, who picked him up afterwards, who may have had him involved and so on. And here, we didn't have any eyewitnesses. For J. Edgar Hoover to be telling Johnson at 4 o'clock in the afternoon on Friday, that tells you the case. You don't need anything more than that. That ends it right there. You know it's not Russia or China or Havana. It's America. And that's the whole case in a nutshell right there. Who, exactly who, and then you get into all of that, and where are the shooters and all of that. But, you know, there's just no question in the world. And then you got the two shooters. Who the second shooter is, CIA. The point is, the door has to be opened. The door open for two shooters. That's a conspiracy in every jurisdiction in America in the federal law, and that means that this case needs to be reopened and reinvestigated. Where it takes you, I don't care. Nobody's going to get medal. There's a guy from the sword, a guy from the bridge, a guy from this building. I don't give a damn where he's shooting from, okay? You got two shooters. Go from there. And why people continue to hold on to this Oswald, it's just incredible to reject all this. Unbelievable. As the sole shooter. Oswald may well have been a shooter. I don't give a damn about Oswald. That's not the point. You want him as, I tell an audience when I speak, you want Oswald as a shooter? Have him as a shooter. Just give me that second shooter, and let's move from there.
So, John, as a federal prosecutor, I have and one knowledgeable in federal law, we talked about this on the phone. The JFK Act does not have a right of private action. In other words, to force Congress, the executive to release the rest of the records, to force Congress to reopen hearings. Are there any other statutes, if Dr. Weck wanted to try to force an investigation, are there any other, that you're aware of, any other federal authority to sort of try to press this?
In my opinion, as I think I've told you, it would take something better than 1 and 2 billion DNA to get this thing shook up at this point. It's so embedded. But I don't think a state or federal authority, criminal authority, is going to do it. I think it needs something like an independent blue ribbon commission.
Again?
Like they had good results with some other things. A truly independent commission who impartially analyzes and is willing to admit all the mistakes that have been made along the way. Then you get the public's attention, then you get the mainstream media, then maybe you got something.
Let's also talk about some of the good things that came out of this.
Yeah.
Mail order of the rifle by Oswald. This case ended that pretty much within a couple of years because not a couple, it was about 5 years. In 1968, the Gun Control Act was passed, which prohibits mail order purchase of firearms. Okay, this was the poster child for that. Number two, police learned something about this case. There was a lot of discussion about how the hulls or the casings were handled. The casings are handled differently now. I mean, they put them in special baggies so that whatever liquid or oils or debris or something that may be on the outside of that can't shake off, and they're picked up, you know, with like a little wire thing that goes inside the casing, and they drop it. They don't even put their fingers on it. These guys have put their hands all over these things. Okay, they learned that. We also learned don't stop when you just find one person. Something this big suggests that there may be more people involved, people helping plan it and so forth. And so I was a federal prosecutor for 4 years. We never stopped after the first suspect. We tried to work that person towards other people and other sources of funding and planning, etc. So this case was very instructive. All right. So
There's actually another interesting coincidence. that the two places that Oswald ordered his pistol from and his rifle from were under investigation by Senator Tom Dodd's committee. They were investigating this whole business of illegal firearms through the mail. Now, they were primarily concerned about the sale of well, he was primarily concerned about these cheap firearms that were impacting negatively the Connecticut arm business. But on his face, the concern was that these weapons were going to the exiles, the Cuban exiles, without any controls. So it's just curious, none of the curiosity for us in this case, the two places that were under investigation by the committee are the ones that Oswald got his weapons from. But John, is there a federal whistleblower statute or anything that somebody could try to use?
I don't know of any. Of course, it wasn't a federal crime at the time, and I don't know of any at this point. And I don't think the federal government's going to budge. They're going to have to be budged from the outside.
Okay, thank you so much for staying with us. I want to thank Jay for all his help, and we hope you enjoyed this presentation.